Good afternoon, everyone. Thank you for joining our CLE on expunction and non-disclosure law. My name is Kristen Salas. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program, or DVAP, as we call it for short. And for those of you that are not familiar with us, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will work their case pro bono from start to finish. We take a wide variety of cases, all civil, um, ranging from divorces to probate, consumer issues. And one of the things that we get a lot of requests for is help clearing a criminal record. In expunctions and non-disclosures. This is the only area in which we enter into the criminal world. So today we are blessed to have Valerie Tabor with us to tell you all about how to do expunctions and non-disclosures. Um, Valerie is a graduate cum laude of SMU with degrees in dance performance and sociology. She attended the University of Law School of Law, getting her JD. She has worked in various district attorney's office, including Dallas, Rockwall, and Kaufman County. She's been in private practice. She's also been assistant public defender for both the Dallas and the Kaufman County Public Defender's Office, rising to first assistant public defender in Kaufman County. She is now the head of our new expunction and non-disclosure section at Legal Aid of Northwest Texas and comes to us with an abundance of knowledge in this area. If you do have questions along the way, please add them into the Q&A at the bottom, and she will try to get to those as needed at the end of the presentation. So without further ado, I will turn it over to Valerie.
All right. Thank you so much. And thank you so much to those of y'all that have joined us today. This is an important give, and I'm going to kind of start with my slideshow because it just kind of moves us through like what we do and why this is important. So I've entitled it Make It Go Away, Removing Barriers Through Expunctions and Non-Disclosures. And why is it important? Why does it matter? Because a criminal record can follow and negatively impact someone for their entire life. It can have hardships on their ability to get housing. It can definitely affect child custody, school visitation, like they can't do field trips and meet at the school with their kids. There's certain federal loans, college admissions, and professional licenses. Obviously, there's the one I care about the most, which is your right to jury service. And I'd like to see people serve on a jury. I'd like to get a real, test of what our community looks like. And if you have a criminal record, you can't do that. And I think some people believe that like charges fall off after a period of time. They actually never disappear. What they do is after about 7 years, most businesses don't look after 7 years for a criminal record. And so when you say, have you been arrested, charged, et cetera, you can, be honest or not honest. But we're hoping for people to be honest. And after 7 years, most businesses don't look into it, but the charges never go away and they hunt you forever. And we're really finding that with the studies that once you've been marked with a criminal record, it just never honestly goes away. So we're telling you, make it go away, make it go away. But we don't have jurisdiction over mugshots.com or publicdata.com and organizations like that. So while we can send them an order and says, take this off your record, there's really no guaranteeing because we don't have jurisdiction over them. But it's super important to try to clear people's records so that they can get the professional license and move forward in their life as they want to. especially for housing. It's a huge problem for housing. Um, so we have our division is expunctions and non-disclosures. So expunctions are basically for people who were arrested and they were never convicted. So maybe charges were never filed or they were not convicted. Maybe the case was dismissed, something like that. And that is actually a permanent, absolute clearing of your record, like without question. It's removed off TCIC, which is Texas Criminal Information. It's removed off NCIC, which is National Criminal Information Center. It's removed. It's removed from the district attorney's office, the sheriff's department, jail detention. It's completely removed. And it doesn't exist. Like I said, mugshots.com and certain public places like that are a little bit slow to respond, but they usually do respond when they get an order. And then non-disclosures are basically for people who get deferred probation, which is probation that they withhold a finding of guilt for the period of probation. And if at the end they successfully complete it, depending on the court, it's either entered in TCIC or NCIC as a no finding of guilt or a dismissal, DISM dismissal. It's not a dismissal like what an expunction would be. It is a dismissal through a non-disclosure, through a deferred probation, but you can get it removed from private America. So if you apply for a job at Amazon or Nike corporate or whatever, ideally they don't see it. Unfortunately, law enforcement can always see it. So it's always still there, but at least it takes it from public, from public idea, but it can be used in certain circumstances, which can include, and we'll go over that, which can include like if they're applying for a license or something like that, like if they're trying to apply for law school or whatever, it can be used. Let me get my arrow to come back to me. There it is. Okay. Okay. So who we cannot help, who we cannot help with expunctions or non-disclosures. Felony convictions. There are some exceptions for veterans, and we'll go over that as we go through the rest of this presentation. But certain veterans can get their record expunged if they meet certain requirements. But if your client calls and says, hey, I went to prison for 5 years, I want to get my record expunged, unfortunately, we can't help them. That is a guilty conviction, and we cannot help them. They can seek a pardon from the governor of the state of Texas. My response is best of luck. Let me know how that goes, because he's not generally inclined to do that. Any offense requiring a sex offender registration. So if it's indecency with a child or continuous sexual abuse of a child or something like that, if it requires sex offender registration, you are not eligible for an expunction or non-disclosure. It is forbidden from the law. Unfortunately, family violence offenses. So if you got a family violence conviction for, just an assault with affirmative finding of family violence, you're not allowed to get it removed from your record through expunction or non-disclosure. I think that the law is behind the times on this, and I think it needs to catch up. But there's only so much that we can do to try to get the legislature to catch up. DWIs, now this is a new rule. You used to never be able to get DWIs non-disclosed or expunged from your record. However, in these days and times, as long as the DWI was not over a 0.15, so not double the legal limit, which is 0.16, or involving an accident, these days you can do a non-disclosure on a DWI. And then there are certain rules in regards to juvenile records in that is very specific. You have to, it could be what we call a SINS case, which is child in need of supervision, SINS. And as long as the crime itself is not actually something that would be illegal if you were of age. So like possession of tobacco or possession of alcohol or truancy, something like that, that if you were of age, it wouldn't necessarily be a crime. So there's certain rules that regard to juvenile records, but you can consider a sealing of juvenile records. Let's see. So expunction of record, removal of convictions from a personal's record, from a personal record. So we just have that. And I said who is eligible for expunction. We kind of already covered this a little bit. If your case was dismissed, or you were pardoned by the governor, if charges were never filed after the statute of limitations tolls. So let's say in most misdemeanors, statute of limitations is 1 year. In most felonies, it depends. It's anywhere from 3 to 5 years. If the case is not filed inside of the statute of limitations, they can't file it anymore. Okay, so DAs have to be on notice what the statute of limitations is, and they have to pay attention. And if they don't file it, they can't file it outside of the statute of limitation. We have Class C deferred adjudications. Those are like tickets. Like if you get a speeding ticket, or even a minor in possession ticket, something like that, and you get deferred adjudication, you are eligible after a certain time period. And we'll go over that as well. Now there is the special rule for expunction for if your case was dismissed through a conditional dismissal or a special program. So I know in Dallas County, they have a lot of conditional dismissals. Like if you donate cans of food, you could consider, getting a dismissal, a dismissal. If you participate in a program like the STAR program, which is a program geared towards people who are engaged in prostitution. If you do the AIM court, which is the court that's geared towards youthful offenders age 17 to 25. If you complete these programs, you are automatically eligible for an expunction. I mean, so that's huge that these people that are going through graduation and finishing this program are eligible for an expunction immediately. They don't have to wait a time period because it's not a deferred. It's a dismissal of the charge. And so that's pretty big. There's some weird rules about identity theft, like if you're able to show who stole your identity. So I won't go into too much time about that. But if you're able to show, Joe Blow took my ID and, ran up credit cards and this, that, the other. If you're able to actually show who the person was, then you could be eligible. And then it used to be that UCW, unlawful carrying a weapon, was never eligible. But they've changed the law at this point, and you can get an expunction for that kind of case. And again, we talked about acquittals and pardons. Found not guilty, go to jury trial. Found not guilty, you're eligible for an expunction. Period. End of story. You're immediately eligible for that. Obviously, you can file an appeal. And if the appeal is granted and the court says that you don't have, that you're no longer liable for this or found guilty of this, granted a pardon by the governor, again, hats off. Let me know how that goes. And it does happen sometimes that a pardon can be based on actual innocence, like new evidence has come to light and they actually found that you're innocent of the charge and release you. And you can be eligible for an expunction in those instances. Let's see. Talked about this kind of already, person arrested but never charged. And it happens all the time, especially in theft cases, and criminal trespass. In the Dallas County District Attorney's Office really doesn't have a policy as far as pursuing theft over 50 or theft over 100 or criminal trespass charges. They just kind of let them be. And you could be arrested 50 times for criminal trespass and it never be filed. And you're eligible for 50 expunctions because they were never filed. And like I said, if when we talked about this, the Class C misdemeanor, if you get a Class C ticket, a public intox or something like that, and it's never filed, it's 180 days, so 6 months after it's not filed. Class A or Class B misdemeanor is generally 1 year. And generally for a felony, it's 3 years. There are some that are 5, but those are generally the ones where you're not eligible for. Now, also the prosecutor can certify that the records are no longer needed. Again, best of luck with that. They generally don't agree to that. So, yeah, they'd have to know that they're never ever going to prosecute this matter, and we'll see how that goes. Class C, this is where you get deferred adjudication on a Class A misdemeanor. So this is one of the rare instances where if you get deferred adjudication, you're actually still eligible for an expunction as opposed to just a non-disclosure. If you get a Class C, if you get 6 months deferred non-reporting probation on a speeding ticket, you're eligible to actually get it expunged from your record, removed completely from your record after 180 days, as long as it's not a conviction, as long as they don't revoke you and it turns into a conviction. It does need to be non-reporting probation, so 6 months non-reporting probation, and you typically file it in the court where it came from, which is the Justice of the Peace. And what I said here in the bottom is from Class B to any felony where deferred adjudication is granted, you're not eligible for an expunction. This is the one exception where you can get deferred on a Class C on a ticket offense, and you can get deferred and be eligible for an expunction. But however, wherever, if you're on probation for a Class B to any felony, and you get deferred probation, you complete it, the best you can get, even if you're discharged and dismissed from probation, the best you can get is a non-disclosure. So it's just one of those weird rules that applies. Sorry, I've lost my button here. Okay. We talked a little bit about some of the certain specialty courts where if you complete specialty courts programs, you can be eligible for a petition for non-disclosure. I'm sorry, for a petition for expunction. Veterans Treatment Court Program is one of those. I know in Dallas, Dominique Collins runs that program. The Mental Health Court Program in Dallas is run through a couple of different courts. Kristen Wade, and it used to be Nancy Kennedy, and I can't remember who took over Nancy Kennedy when she went to the Fifth Circuit Court of Appeals. But Mental Health Court Program, if you complete that, you are eligible for an expunction. You can get it off your record. And obviously, Crusoe's office is really big into pre-trial intervention or diversion programs. So, it doesn't have to be a 6-month-long program or something. It can just be like AIM Court, which is a youthful offender court, that you go into the court and complete the program and the case is dismissed and you are immediately eligible for an expunction. And then we have the last one, which is conditional dismissal for completion of an order program. And that's where kind of sometimes it comes in like you donate cans of food or something simple, or you make a donation, otherwise, or you do 20 hours of community service, or you do an anger management program or something simple like that. And you're eligible immediately after they dismiss your case for an expunction. So that's kind of nice. And the good thing is Crusoe is really good about that. This is the weird rules I have about identity theft. And only so if you're able to find out who did it, who stole your identifying factors, your identifying information, they will withdraw your name from the case matter. And they can, if you know who it is, insert the actual offender based off that. And because sometimes people give the fake name, a wrong name, or whatever, and the person winds up getting arrested as a result, and so it could be called clerical mistake or error if the person, if you're able to show this is not me. I was not arrested. This is not me. Someone gave my name. If you're able to show that, then you can at least minimum get your information redacted. If you know the person who used your information, then they will insert that information instead. So that's kind of nice. Okay, moving on. We have sorry, we have the expunction petition itself, which will be filed in the county where the offense occurred. So if they got arrested in Dallas County, you file in Dallas County. It will give you an X number. And like right now, it'll be X dash 24 dash, let's say 1009. So you're the 1009th person who's filed a petition for expunction this year. They literally go in order and they'll assign it a random court. So it doesn't necessarily wind up in the court where the case was actually out of. But like I said, X dash 24 dash 1009 dash 265, for example, which is Jennifer Bennett's court. It'll be assigned one of those courts. Your client is required to sign the petition to verify that the facts in the petition are true, which includes your name, sex, race, date of birth, social security. Now, on the social security, I still tend to put just the last 4 digits. It's not required that you put all of it there because this ultimately could be, open to the public while it's pending. So I generally just put the last 4 social. As long as you have the driver's license, address at time of arrest, agency. And this is where you have to start really thinking outside the box about, because in your petition, you're going to file that you give notice to public agencies, which includes district attorney's office, sheriff's office, jail detention services, the arresting department. If it's Duncanville, it's Duncanville PD. And again, the Duncanville jail detention officers. You really have to start thinking outside the box about where this information could show up. And it's really important. Like I said, we don't control mugshots.com or publicdata.com, but we can at least send them an order and kind of scare them a little bit that they need to remove this information. But at minimum, if it gets released or gets removed from public agencies, that's amazing. And now the private agencies, and we'll go over this too, that could include like your local who got busted area. Like I live in Rockwall, and Rockwall has rockwallian.com, and they put on their website who got busted last night. And that needs to be included in there too. And again, while we don't have control over these organizations, when they get an order, they tend to, fall into place. So once you file your petition, I can get my arrow to come back here. Once you file the petition, you try to put in there all these agencies. If here's examples: the arresting agency, the county DA's office, sheriff's department, county jail, chief detention, district or county clerk, Department of Public Safety, Department of Licensing and Regulations. And then you have your Texas DPS, like if they get arrested for a DWI, and it goes into, oh, your license might be suspended or whatever, it goes into there. So you have to really think about these agencies, because every one of these agencies, it's about $7 to send a green card notice that they've received it. And so here's how it works. After they receive a green card notice, they have 30 days to object. I don't know why my arrow keeps disappearing. So they have 30 days to object. If they don't object, and the only person who generally rejects or objects is the Texas Department of Public Safety. For whatever reason, they have someone who works there and they object all the time. Even if it's outside the statute of limitations, they just object in general. So it's very frustrating. But they have 30 days to object. So you send your petition out. They have 30 days, and then you wait for these green cards to come back to the county clerk, because the district clerk or the county clerk is the one who's going to send them out for you at $7 a piece. All right. That's part of the fee. And they'll get the cards back. And then if there's no objection, then you can have your hearing, or you can get the order signed by the judge. You don't always have to have a hearing, but you can at least get the order signed by the judge, or you can have a hearing, is my point. All right. And that afterwards, and this is what mind boggles me, afterwards, the district attorney's office holds on to the order for another 30 days for another objection period. I don't understand. I would love to go to Austin and argue this matter. It just doesn't make any sense. They've already had their 30-day objection period. And then the DA's office gets the order signed, and then they sit on it for 30 days, and then they send it to Austin. So here's some examples of private agencies, like I said: Public Data, Experian, First Contact, Mugshots, Local Community Who Got Busted. You just have to let your fingers do the walking, and figure out where. All right. This is an example of a petition for expunction. And I've actually included this blank sample in the materials that I will ultimately send to you, just to have a copy, and go from there. So this is what we talked about. So once the expunction is granted, the clerk sends the certified copy to the crime records desk, which we call the Austin desk. And just mind you, if you will, there's like two that work at the expunction desk, and the files just like climb above their ears, because every county of 56 counties in the state of Texas sends these expunctions there, and so they start to get buried. And like I said, the DA's office holds on to the signed order for 30 days, and then they send it to Austin. And then Austin has a period of time. The statute, however, does not designate a deadline for compliance. So they don't say, oh, inside of 30 days or 60 days or whatever, you will have entered this into NCIC, that this record is removed. There's no deadline. And so, unfortunately, especially crawling out of COVID, there's no guarantee on when it's going to be entered. So I generally tell my clients that from petition filed, order signed, order sent in, I generally tell my clients anywhere from 4 to 6 months, because order signed, order entered, put in the computer, and removed, 4 to 6 months. And that's being generous, honestly. Sometimes it takes longer because Austin desk is just buried in files. I can't blame them. They need more help, but that's above my pay grade. So, yeah, and that it is actually a crime if you, disseminate this information after an order has been granted. It's actually a crime. Um, does it ever get filed? No, but it's actually a crime. All right, let's see what we have. Okay, next. So now we get to non-disclosures. That covers expunctions. So if you have any questions on expunctions, please go ahead and send them to me specifically, and I'll try to answer those as we get to the end of this. Now we get to non-disclosures. Again, a non-disclosure is court order prohibiting a public governmental agency from sharing or disclosing certain records. And like I said, there's certain exceptions, and we'll go through those exceptions. They're called the Chapter 411 categories. And that includes, like, if you apply for a job or if you apply for a license with the state bar, they're going to give your information out. If you get certain professional licenses, they're going to give your information out. It does not require destruction of records, but still can be shared in some instances, and we'll go over that. But what it does is when the petitioner is filing to try and, like, get a job, like if they apply for a job, like I said, at Amazon or corporate Nike, and it says, have you ever been arrested or charged? You can say no. Have you ever been convicted? You can say no. That's huge. If you can say no, I've not been charged, convicted, etc., whatever, that's huge for their record. And like I said, most companies only go back like 7 years, so it's not a huge deal. But if you have a recent record and you're trying to get a job and clear it, this matters. I said it must fit into one of the express categories, and we'll go over that in a minute here, about who they can disclose to. I keep losing my mouse. Okay. Okay, so this is really a one-time get out of jail kind of card, right? You successfully completed a deferred probation. You have no other convictions or deferred adjudication through the end of the statutory period. So, like, you completed your probation and you're done and you haven't picked up any other offenses. It's really a one-time get out of jail free card. Never convicted or deferred adjudication. These are the ones that are not allowed. Okay, if you get deferred adjudication, anything requiring sex offender registration, no. Murder, no. Human trafficking, no. Injury to an elderly, no. Any kind of case involving a child abandonment, or injury to a child, no. Bond conditions and domestic violence, so like violation of protective order, no, you're not eligible. Obviously, sexual assault, stalking, and trafficking cases. Now, there actually is some rules about trafficking cases that if you are a victim and you can show that you're a victim and you assist in the investigation, you actually can get your record clear. Now, it's got to be all of that stuff, that you are a victim, you assist, you help, and maybe bring someone else to, justice that you're a victim of yourself. But it's pretty narrow. It's not used a lot, but it does exist, and that's good to know. And again, unfortunately, any offense involving family violence. So if you get deferred probation on an assault family violence, let's even say for a BS case that you just took deferred just to move on, get it over with, you don't even care anymore. Yeah, it's not coming up your record. So that's pretty rough. Because a lot of people do just take cases, just take deferred, just move on. They just want to be done. I've seen it happen in my 23 years of practice. But they can't get it removed from their record. So you have these are the ones that are, if you complete deferred probation, these are the exceptions. The ones that are eligible for automatic non-disclosure, which we've already talked about. If you get a dope case of possession of controlled substance, you complete 3 years deferred probation and you finish and you don't have any other record, boom, you're eligible. Okay, no problem. Deferred adjudications generally across the board. There's some of the exceptions like we talked about before, sexual assault, things like that. Misdemeanor convictions on deferred probation are generally eligible. DWI offenses, if you get deferred and if you get, if the case is not a 0.15, or involving an accident, you could be eligible. Veterans court completion, if you do veterans court completion. And then here's the weird little rule about victims in human trafficking and compelling prostitution. So if you're a victim of that and you can show that you're a victim, you might be eligible to get this off your record. So we kind of talked about this already, which was the nonviolent misdemeanors, automatic non-disclosure 180 days after sentencing. And like I said, nonviolent misdemeanors, burglary of a motor vehicle misdemeanor. You get deferred probation 6 months after you complete deferred probation and you don't have any other cases that you pick up, you can get an expunction, or I'm sorry, you can get a non-disclosure. Again, anything other than DWI would be no waiting period. It's immediately available. Unfortunately, DWI is 2 years. So if you get deferred probation on DWI, you're eligible 2 years after you finish your probation. And felony is generally anywhere from 3 to 5 years. It kind of depends. I put 5 years here on my slide, but it kind of depends on the charge. And that's where the attorney gets involved and digs in and is like, okay, what exactly, when exactly are you eligible? Where is my mouse? Here it is. Yeah, as I'm going through it, I'm realizing I already covered most of this, which is fine. But yeah, 2 years. So after an assault, successfully completed probation or jail time with no priors ever, you're looking at 2 years. Non-violent probation, like I said, burglary of motor vehicle, you're looking at no waiting period. And if you plead to jail time on a misdemeanor conviction, let's say you plead to 2 days time served on a misdemeanor conviction, it's 2 years after the completion of the sentence that you can get a non-disclosure offered. So yeah, I mean, yeah. And that's what I have in the bottom area here. Blood alcohol content under 0.15 and successfully completed probation or jail time with no priors over. It's anywhere from 2 to 5 years. I find that the DWIs are the ones that require the most attention. Assaults are never in there, and that's probably second to DWI. But criminal trespass, anything like that, 2 years after, well, not criminal trespass, because that would be a non-violent criminal case, but that would be immediately available. It could be an assault that there's no family violence finding, and that would still be 2 years after you complete probation. So I would love to change that law, but again, it's above my pay grade. All right, we're almost done. We talked about veterans court, successfully complete the programs. It's not a DWI, non-sexual offense. It's 2 years if you complete the program. If you complete veterans court, let's say on a burglary of a habitation, it's 2 years after you complete it. And then here's the rules for victims of human trafficking. If they got assisted in the investigation, if they were able to assist in the investigation, it's 1 year. So it all comes down to just regular rules. Petition for non-disclosure, it's kind of the same way in a petition for expunction. You actually file in the court that issued the actual case. Um, and so it's not going to wind up in XYZ court. It's going to wind up in the court that it's supposed to wind up in. They don't actually have a list of what you need to have, but I just follow the petition for expunction, and I just put all the information: name, date of birth, race, sex, etc. And put the same stuff. Because of the job that we do, we tend to have clients who are meeting federal poverty guidelines, and they're not able to pay. So we gather a statement of inability to pay because they cannot pay. If they don't meet our guidelines, they're not going to wind up as a client with us. So they might wind up as a client with you or otherwise. And we gather the statement of inability to pay. Usually in a non-disclosure petition, the state wants to have a hearing. They usually want to object. Oh, it's not in the best interest of the court. It's not in the best interest of justice, whatever. So they usually want to have a hearing. So expunctions, you rarely have a hearing. So when I ask you at the end of this to volunteer for expunctions, take an expunction because they are easy breezy. Non-disclosure, I still think they're easy breezy. Most of the time, the state will ultimately acquiesce and give in and go, okay, fine, I'll agree. But that doesn't mean that you don't have a hearing that is set, and then you have the stress of like, oh, I have a hearing that's set. But usually they agree. So it's really not a big deal. But you do have something on your docket, and if you're not a litigator, I understand that that makes you nervous. Okay. This is an example of petition for non-disclosure. Like I said, the information is not required under the statute. So yeah, they send out the same notice. They send out within 15 days to all the organizations, the public agencies that you've identified, and it is going to be unique for every petition that you file. And this is actually one of those where they do have a time period. They have 30 days to seal the records. 30. Now, does it often happen in 30? No, but we at least know that there's something there. And this is where I get to the bottom here of when they disclose the information. And like I said, they can disclose the information to the medical board if you apply for a kind of medical license, board of law examiners, that does not surprise me, state bar, board of nursing, Texas Education Agency, and board of pharmacy, and the Texas Department of Insurance. So if you get a non-disclosure granted, do not want to go to one of these jobs and get one of these licenses because it will likely not happen, right? Medical board, board of law examiners, state bar, board of nursing, Texas Education Agency, board of pharmacy, and Texas Department of Insurance. If you want to do any of those jobs and you have a non-disclosure on your record, I'm probably going to tell you you need to look somewhere else. Sadly, but that's probably what I'm going to tell you. But it at least clears it from the rest of public America. Take that as a win. We have some information here on sites. Our Dallas, I'm so excited that our Dallas Volunteer Attorney Program put on this program for us today through Dallas Bar Association. And we have various ways that we help. We would love for you all to consider applying through Dallas volunteer attorney program and join us and agree to take on an expunction or non-disclosure. We have them just pouring in on a daily basis. And little old me and my poor paralegal, we can't handle them all ourselves. So I don't want to turn people away because we're just too full. I want to be able to say, oh, I've got a DVAP person who can join. So I would encourage you to really consider it. And I have that information here at the end. I can get my mouse to cooperate. Oy vey. There we go. Okay. Yeah, like I said, I ask that your applicants, your persons they Google themselves and try to find like where information is. They can always go to Identigo. They can get their own report. And they need to help you file the petition. And then I think I'm at my last one, which is volunteer. So here's my information through Landwit. I encourage you to reach out if you have any questions and try to get a hold of us. We're at legalaidtx.org. Our emails are landwit.org, and here's our numbers. But for volunteering, let's see. I just need to get to the last slide, and then we'll be good to go. We need volunteers. We need volunteers. All right. So we give you the documents. We give you the blank documents. Have your client fill them out, file with the board inside 30 to 45 days. You get your orders, and that's it. And then here is Holly Griffin's information through the Dallas Volunteer Attorney Program. So I'm going to leave this slide up and take any questions if anyone has any.
Thank you, Valerie. That's an insightful presentation. And for everyone wondering, yes, a copy of the slides will be sent out to attendees today, as well as the MCLE course code, which I will also give briefly following questions. We do have 2 questions as of right now. First question, can a person who satisfied deferred adjudication and the case was dismissed after the satisfaction have his or her record be expunged? What offenses are not eligible for expunction in those cases?
They're a Class C deferred is the only one that's eligible for an expunction. So like a ticket. If they did deferred probation on a Class B, Class A, or felony matter, the best they can hope for is a non-disclosure. The only one they're eligible for an expunction is a Class C ticket case.
Thank you. And then, the next question was a copy of the useful information and tools. Yes, we will provide a copy of that for you all.
Yes, absolutely. And I did also include a checklist, checklist 1 and checklist 2 for non-disclosures and 1 for expunctions. And so it's just literally check, check, check. And once you check that stuff off, you can successfully file a petition for non-disclosure.
Perfect, thank you. And then for attendees, I will read out the MCLE course code, which will also be emailed to you. But the code is 174-234-139. Again, that is 174-234-139.
Perfect.
Thank you. And I'm not seeing any additional questions. So we thank one more. Is there a checklist for juveniles?
No, I don't have one for juveniles. It really depends on the nature of the case. Like I said, if it's a SINS case, which was child in need of supervision, which is something like truancy or smoking or public intox, something that would be legal other than being a juvenile, those are the kind of cases that are eligible for a sealing. So I don't have a checklist yet, but I can work on that. Thank you for letting me know.
Yes, thank you for suggestions. Okay, well, we give you the last couple minutes of your afternoon back. And again, we thank you for attending a DVAP CLE. And we hope that you will all sign up to volunteer to take expunctions and non-disclosure cases. So
Yes,
thank you,
please.
Valerie, for doing that quick little plug. I will be following up with everyone via email with following today's presentation. But thank you all and have a good rest of your afternoon.
Thank you so much. Have a good day.